Hello everyone, I am Advocate Sulaiman Bhimani and I welcome you all to the Citizen Justice Forum video channel. Our mission is to empower Indian citizens by sharing knowledge about their fundamental rights as specified in the Constitution of India. If you are watching us for the first time, don't forget to subscribe and click the bell icon and select all so you receive notification whenever we upload a new video or go live. Sharing this video with your contacts and friends would be greatly appreciated. आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना है जो भारतीय संविधान ने उनको दिए हैं। अगर आप हमारे चैनल पर पहली बार आए हो तो कृपया इसे सब्सक्राइब कीजिए और बेल आइकन को क्लिक करके सबको चुने ताकि जब भी हम नए वीडियो अपलोड करते हैं या ऑनलाइन आते हैं तो आपको उसकी सूचनाएं मिलती रहे। हमें बहुत खुशी होगी अगर आप ये वीडियो आपके संपर्क और दोस्तों के साथ साझा करेंगे। आज का जो विषय है रीडेवलपमेंट ऑफ कोऑपरेटिव हाउसिंग सोसाइटी फिजिबिलिटी रिपोर्ट को समझने और DCPR 2034 के तहत सही योजनाओं का चयन करें। Today's topic is redevelopment of cooperative housing society, how to understand the feasibility report and how to choose right schemes under DCPR 2034. The keynote speaker of today's topic is the highly esteemed personality, Mr. Samoon Rassiwala, the founder of the Samoon and Associates Architects, Engineers and Valuers, a well-known and established personality. He has an extensive experience of 47 years. He spent the initial 10 years of his career in an architecture firm, followed by founding the Samoon and Associates. His expertise lies in the industrial design, master planning, restoration of heritage structures, large-scale redevelopment, and licensing. Few of his significant projects include master planning and end-to-end project managing, construction of textile mills and chemical plants. He also played an important role in the early stages of planning of the Bindi Bazar cluster redevelopment project, which is supposed to be the India's largest cluster redevelopment. He plays an active part in the numerous community projects such as the construction of mosques as well as the redevelopment of existing ones, keeping the essence intact along with giving as a renewed character, working with integrity at Samoon and Associates flows from Mr. Rassiwala. It is of utmost importance to him to be counted as being 100% trustworthy and accountable by his clients. His thoughts, actions, and decisions are driven by his principle at all the time. He values his relationship and gives importance to each point. He is consciously retains the humility in approach to making individuals at ease during his interactions. He believes in benefiting people around him and he is involved in various philanthropic projects and looks towards the opportunities to uplift the community. He also plays an important role in land clubs at the district level. We have with us Advocate Vinod Chabra, author of the Cheque Law Reporter, and Mohammad Afzal, who is the campaigner of the consumer rights, who will co-host this webinar. And let's hear from Mohammad Afzal before we give it to Mr. Samoon Rassiwala.
It is very important for citizens to know whether it is redevelopment or self-redevelopment. जब मैनेजिंग कमेटी आपके सामने feasibility report पेश करती है तो अक्सर हमने पाया है कि जो ऑर्डिनरी जो मेंबर्स हैं वो पहला पन्ना भी टर्न करके नहीं देखते हैं और सारी चीजें वो डिपेंड करते हैं कि भाई रीडेवलपमेंट कमेटी हैंडल करेगी। मैं समझता हूं कि हर वो मेंबर, क्योंकि आपकी हार्ड अर्न मनी है, आपका प्लॉट है सोसाइटी का और फ्लैट आपका है, तो ये बहुत महत्वपूर्ण है कि आप फीजिबिलिटी रिपोर्ट के हर वो चीज को समझ लें और समझने के पश्चात आप मतलब जो रीडेवलपमेंट और सेल्फ रीडेवलपमेंट कमेटी है उनको सौंपें ताकि वो डे टू डे निगरानी करें। इन्हीं सब चीजों से मैं अभी रसीवाला को देता हूं कि वो आगे बात करें।
Good evening, everybody. First of all, I'm thanks to Advocate Sulaiman Bhimani for giving a very lengthy my introduction. Thank you very much.
I was cutting it short, otherwise it would run for 1 hour.
But see, these are the long experience in the field of the licensing and approval. But if you start my detail, it will again take long time. I will come to the today's topic directly. Now, today's topic is the feasibility report. Now, what is the importance of the feasibility report? Why do you require? Feasibility report is required for any redevelopment, or I will say any development project. While you see the technical and as well as the economical requirement. So, if both the requirements are to be fulfilled in the feasibility report. So now, how to prepare the feasibility report? Now, feasibility report is prepared by a technical person, licensing or architects who are working in this field. They prepare, but they prepared on a certain documents which has been given to him. Now, the society, when he approached these licensing architects or architects, then you have to keep a certain documents ready. And for this, I will give you details of the documents required. First of all, the property register card. It is very important document for society. Then is details about the area of the property and name of the holder of the property. Then you require city survey plan, and that is give the details about the existing structure or plot boundary, everything. Then for redevelopment, particularly for society, the exist plan of the existing building, the approved plan of existing building is very important, because based on that approved plan, the further development will be considered, because the basic is the authenticity of your existing building is very important. There are so many alterations have been done in the life of the building, but that is, if it is not done with the approval, that is not considered. And secondly, it gives the time when the building was constructed. It gives a proof. Now that was age of the building also is come in the approved plan. The city survey plan also is one of the proof is required when by way of the authenticity of the existing building. Secondly, if you don't have the plan, then there is next alternative is assessment detail. Assessment detail available with the corporation by way of annexure A or your inspection aspect. So after this, all this area now, when based on the document given, the first important is the existing building. The government, the corporation goes for this existing building plan. If the existing building plan has the occupation, then existing building area given in the occupation plan is considered for redevelopment. If existing plan is only approved plan, there are two things. Building is started, there some plan are there, then occupation, there are plan changes. So during the construction, whatever the changes are, they will come in occupation plan. If you don't have occupation plan, if you have any approved plan, this also will give you a benefit in the preparation of the project report. Then built-up area given in the approved plan also will consider. If you don't have the building plan, then you don't have anything, then it's very difficult for the society or licensing architect to obtain the permissible built-up area. The other alternative, as I talk to you, is assessment. The area given in the assessment will be considered, and number of tenement, everything will be considered. Now, if you don't have anything, then you have to obtain any document proving your existence of the building prior to datum line. The datum line is for a residence building is 64 and commercial is 62. These are any proof of existence are required. But these are for very old building and which has been constructed before the developers would come. Now, number of tenement, because redevelopment is also part. One is the development built-up area and number of people to be accommodated. Number of people to be accommodated will depend again approved plan, then development plan, then assessment detail. Everything will be considered during this. Okay. Now, after all this has been there, the when the feasibility report is start preparing, the first important document which comes is the preparation of the tenant list. Now I will show you the a slide giving the details of the tenant list. Now the tenant list is been put up to you. Now tenant list consider, you see the tenant list chart. There are two parts. We have seven. There is in this part, all which are the floor, where what is the tenement, what is the user of tenement, what is the existing area. This is given. Then existing area which is required to be permitted, provided. It is the minimum area which is required to be provided. There are some additional incentive given in various schemes in redevelopment, either 5%, 8%, 15%. This has also been added. So these are the requirements. Then accordingly, then above this area, there are fungible area which has been available. So also that is also been added. So ultimately, finally, every tenement, as per the rules regulation, what is permissible to them and what they give you, they will get it minimum. This is a minimum area. So this is the minimum area they should get it. Now, when the developer may give you more, depend on his fund available and your commercial aspect, everything, that all will be negotiated in different way. But these are the minimum area as per the rules which is required. Now, by feasibility report, the very other important is the ready reckoner. All the feasibility report prepared on the present regulation as well as the ready reckoner. Government change the land rate and the premium rate, everything depends on the every year on the land rate, there are changes. So that is also be considered. The other point is consider the construction rate is a varying construction rate is given. Now, in redevelopment, again, very important aspect comes is the rent of the tenant. Rent during the transit period, during the construction period, tenant will be given rent. That also be considered. Then even the corpus fund is to be considered. All these come under feasibility report. All this is considered in calculation. Now, if you go to the feasibility report, the first part will always go for the legal aspect of the land. The land, first of all, whether it is important, whether the land is in the name of the society. If the land is not in the name of the society, then it is required that has to be brought in the name has to be come under property card. Because while approval, this is very important. So the first part in the feasibility report will contain the details about the legal aspect of the land. Then second part will be then even that also in that particular, if it is a freehold land, is a lease land, this also will be mentioned. Because if it is a lease land, if it is a government lease land, if it is a municipal lease land, then all this will be changed. The development regulation as well as the charges for the payment will be also changed. Second part will be coming is the on development plan, DP remark. Now I will show you the typical DP remark. The DP remark is very important. This gives you the status of your land. The one is was the legal aspect. Now the DP remark will give you technical details about your property. Now that will also cover whether the property is a reservation, if it has been affected by road setback, if it has been coming in the heritage area, it is coming in the coastal area, or it is coming in the other restricted area. It is some area where we require height restriction, everything. Then everything will be mentioned there. And particularly reservation is very important. Now this is the typical DP remark I have displayed to you, and in this DP remark, the particular road line, everything will mark, and all these are to be studied by the person who prepared the feasibility report, and it is also affect your redevelopment. So it is important to understand the redevelopment with respect of reservation. Certain society, say our property is already been developed, but they have been affected by road widening. There are some other changes that we could come after the plan has been revised, because development plan are prepared every 20 years. Now the last development plan, which is now come in the fourth from 2018, it is 2034. Development plan is for 2003. Now, if the next slide, if you see the next slide is the giving the plan, showing the plan giving the area, plot and surrounding areas. This gives you will see the plan. There are some reservations on municipal school, police staff, everything. But the plot under reference has nothing to doing. Is very clear. So this gives a very clear idea that there is no reservation on the plot. See, this is very important. The plan has to be seen. One more plan is also been come in the development plan, which give the direction. What is the road? The property is abutting which road? What is the width of the road? Because FSI based on the width of the road. All these come in a second plan. So these are the development plan is very important. The second part of the feasibility report will be the development plan and detail what is the requirement. So there is a very important aspect. All this has to be understood. Every property is different from other. If you see one person and you cannot compare the other person. Similarly in the property also, one property, one plot cannot be compared with other plot because every have their own janam kudli. Janam kudli by way of the legal aspect as well as the DP. All this has to be considered in feasibility report. Most of the people don't go for this detail and come to directly the calculation. What is the regulation available? Now, as of today, there are so many regulations which has been applicable to the redevelopment of society. Now, if the road width, this FSI is given in a with of road width, whether plot is vacant for redevelopment, whether there is a danger building demolished or to be constructed, then there is a different allow is applicable. Then there is a building which is having age of 30 years or more. Then what is the occupation? If you are constructing a very good commercial building, then the project report will be different. Feasibility report will be different. But if you are comparing residential user, then feasibility report will be different. All these are come in the effect under development. If there is reservation, then the development is completely different. What are the area to be given to corporation and how it will be affect your development. All these will be covered. Now, the very second part of the today is what is the regulation applicable to society. There are so many regulations for redevelopment, and all these redevelopment there are given in the regulation very clearly defined, and all detail are given. First of all, I talk to you is the regulation under 33A, where it is all FSI is given on the basis of road width. And if the road width is, if the road, your building plot about a plot which is less than 6 meter road, then you have a single zonal FSI. No further FSI will be available. Minimum, then if you have a 9 meter, there is certain additional FSI given. If it is 12 meter onward, there is again 18 meter onward, there is difference. But all these additional FSI is come at the cost. Is a premium to be paid, other and by TDR to be taken. Second aspect is the 33(7). This is the safe building. That is the regulation also applicable. Mostly these are safe buildings are in sub city where it is been handled by MADA. They are being repaired safe. That is applicable to them. Then 33(7)A. 33(7)A is the redevelopment of unsafe building, tenanted, particularly tenanted building in suburb that be unsafe and will declare danger and to be redeveloped. That comes under 33(7), and that is a very important aspect. All the existing building plan are required in there. Then 33(7)B, which was the most of the building which is having age of 30 years and constructed in 60s, 70s, 80s, then they are coming under this particular category. That is also there is some benefit, but major benefit in 33(7)A is regarding additional FSI of the road. Now, all these about 33(7), there is a master regulation is called cluster development. That is under 33(9). If you have properties, a small property, if you are coming together and making good, or the plot is more than 4,000 in city of Bombay and 6,000 in suburb, then you can go for a cluster development. And cluster development has a more benefit for existing tenant. They get more area. The individual area also been given minimum 35 square meter plus, depend on the size of the property, the additional entitlement. So there are so many other benefits under cluster development. As well as there are benefit for additional FSI, which is important. But if you are there are some drawback. If it is property, you have less construction area, then you may have to give some area to MADA and government. That is provision there. Then there is a provision, there are other regulation 3311, where it is construct a transit tenement and give it the transit tenement, you get a benefit of construction after giving transit tenement to government, you can have the benefit of that area in your development. So that is 3311. Then there is the provision 3312B. 3312B is the particularly tenement coming by the corporation are required to remove certain tenement from the development road and other footpath and other things that is required to be reaccommodated. You can reaccommodate them as per this additional FSI. You get it and you have to give hand over this area to them. But this all these have take 3311 and 3312 is important unless the society is ready to accept the tenement coming from the corporation and government in their building, then only this will be applicable. Otherwise, you have not to, if you just think twice before you take it over. Then there is a 3318. There is a 3311 if you have public parking. You can provide a public parking in your society planning, but that minimum area of the plot and the minimum width of the road is required. If you are eligible for that 3318, then you can go additional FSI and then you have to give the parking, public parking to the corporation. They will manage, but you get a FSI benefit on construction of that. Then 3319 is the when you construct the building with fully commercial. If you are going for a commercial building, 100%, and then whether with some small requirement for residential, then this is applicable.
Here we will take a break, right? And we can have a question and answer of two questions which have come for check bouncing matter, right? The query is that I was accused in a case of check dishonor in a magistrate court of Gujarat. On the day of the final judgment and order, I was not present in the court. The court convicted me, imposed a sentence of 1 year, and directed me to pay the check amount, which is in crores. The court also issued an NBW, that is called known bailable warrant, against me. My advocate went to file an appeal before the Sessions Court, but the court staff said that I should first surrender before the trial court. As a result, my appeal was not registered. What should I do to protect myself from arrest, and how should I file an appeal against my conviction order?
It's a very practical proposition, and I truly appreciate the person who has put forward this question. This is normally very normal practice, and nothing is going to be harm if they put into a case the accused on the date of pronouncement of the judgment. But it is very important that on the date of the pronouncement, if the accused is not come present before the court, even if his advocate is present, but the accused fails to appear before the court on the date of the pronouncement of the court has got no other option except to issue his NBW. And NBW here, I would like to go further. I would like to define the NBW of two types. Once the NBW is, the purpose is to secure the accused before the court, that order is issued under section 70 of the Criminal Procedure Code. But here the proposition is different. The secure of the accused on the date of pronunciation is not the paramount consideration. The paramount consideration is when on the date of the pronouncement the accused himself has not come to appear, and after the honorable court comes to conclusion that he has committed the offence and he has held the accused guilty, and he has not moved an application suspension of his sentence, whatever is in this case, I think he is convicted 1 year offence along with to make the full payment of the check amount. So in that scenario, it was incumbent upon the accused to appear before the honorable court and to move application under section 389 subclass 3, showing and writing in detail that I'm not satisfied with the judgment of this honorable court. So it is my prerogative, my privilege to assail the validity of this judgment before the higher authority, that is session court, concerned competent session court. So if he wants to file the appeal against the aggrieved by the judgment, Normally the court has got no option, no discretion to decline that application. The court in all probability will grant that application, will accept that application and give time to the accused, normally 30 days. 30 days in order to make him unable to go to the session court and file the appeal. But here in this question, whosoever the questioner is, has not cleared that when the judgment was pronounced.
No. Here he says my appeal was not registered. So he had approached the second court. His appeal was not registered.
Okay.
So how do I protect myself?
Okay. In this scenario, if the pronouncement of order to approach the session court, the period is 30 days or within 30 days, then the court has the liberty, court has the privileges, court has the saving umbrella upon the accused to protect him. He should first surrender before the court, move an application if that is within 30 days. Within 30 days, the court will absolutely accept his application, even on the date of the pronouncement of judgment. He was not available. So he had to justify that whatever the reason that stayed him that he could not appear on that day, that is a secondary material. But court don't go in the much merit on that respect. Court will provide him 30 days. But here the proposition is different. If he has not appeared within 30 days and has not, then go to the session court. Session court, particularly in Gujarat state, that is a quite little bit different from all over the India. They don't accept the appeal, they don't register the appeal, they impose the condition, sine qua non, precondition that you first go surrender before the trial court, get your order, prevailing order of 4182. That is a conviction order. Basically, that is a conviction order to accuse and put him behind the jail and to start the sentence. In that scenario, the accused has to be very conscious, very clear. He should have engaged a very competent lawyer, because here the discretion of the courts come into play. Here there is no discretion with the court. The court can decline and court can accept. So both the weightages are in the hands of the court. So he should be very clear. But in that scenario, if the 30-day period is gone, suppose he has not gone to surrender, then his appeal is not going to be registered, particularly in the Gujarat. Then he has only a legal remedy to approach High Court under Article 226-227 by moving specific application. That I just want to file appeal. I am not satisfied with the judgment of the lower court under Section 375. That is my prevailing right. That is my statutory right, and that is my vested right. So normally, in such a scenario, the court will order and court will provide 7 days. You go to the court, file appeal, and in the meantime, you will be protected. So far,
Now, second question is in Hindi. मेरा सवाल ये है कि मैंने एक व्यक्ति के खिलाफ 2 करोड़ रुपए का मुकदमा दायर किया है। मुकदमे के दौरान अदालत ने आरोपी को देय राशि का 20% भुगतान करने का निर्देश दिया, लेकिन वह भुगतान नहीं कर रहा है। विश्वसनीय सूत्रों से सुना है कि वह अपना 5 करोड़ रुपए का फ्लैट बेचने जा रहा है। उसके पास कोई अन्य संपत्ति नहीं है। हम एक करीबी रिश्ते में भी है। वह 70+ वर्ष के है और हृदय संबंधी समस्याओं से जूझ रहे हैं। मुझे अपने आकस्मिक अधिकार और 20% देय राशि की सुरक्षा के लिए क्या कदम उठाने चाहिए?
In this case, the questioner is a complainant. As per the question, the court has granted 20% of the check amount in his favor. How much the amount check amount is?
40 lakhs.
2 crore.
2 crore है.
2 crore.
20% 2 crore 40 lakhs.
20% come to 40. If the court has passed the order to giving direction to the accused to pay 20% of the order, then the only option with the accused, if the suo motu by his own showing his good conduct before the court, accused is not coming forward and deposit that amount to the court, that will ultimately release to the accused. If the accused suo motu don't deposit that amount, then the remedy available with the complainant to move an application under Section 421 of the CRPC, asking the honorable court to attach the property of the accused, to sell the property of accused, and out of that sale conciliation, whatever the check amount is, that is 40 lakhs, that is to be granted to the complainant. But here another part of the question, he says that the accused is of 70 years. 70 years. So in this scenario, I will definitely like to advise, not only just answer, I would like to advise immediately, without failing a single minute, the complainant should file the simultaneously civil suit he will shoot for recovery because he is a 70-year-old and according to his heart patient. If he is heart patient, unfortunately, if he's gone in the second hand, the complainant would be on the road and his whole total amount of 2 crore would be just be. So in this scenario, I specifically advise immediately go to the civil court, file a summary suit under 37 of the CRPC. Along with he has to move an application under 38 of the CPC for attachment of the property, and out of the sale proceed his 20% be given and remaining part be kept in abeyance.
Yeah. So once you see that if the accused is super senior citizen, then you have to file a civil suit so that your properties are protected. Otherwise, only in 138 the complaint will not survive if the accused goes to the other world. Right? So thank you for the two questions. Now, before going to Samoon Rassiwala, I would like to clarify that the feasibility report is not only a mathematical calculation that I have 400 square feet area and I will get 35%, that is 140 square feet, more, that is 540 square feet, and that's all. No, the feasibility report will contain the history right from the day one when the plot and how the plan were passed, right from the CC to occupation certificate of the existing building or of the existing society, and whether there is any reservation or whether there was any reservation, or whether at that time there was road setback which was taken away by the corporation, and whether that setback was given to the builder or to the society. Everything has to come in the feasibility report. It is like an essay, and then it comes the what you call the calculation. Am I right? So if you have any question,
yes.
Yeah. So and then we can. Still, this feasibility report is not completed, but we had a break so that everyone gets a chance.
सेल्फ रीडेवलपमेंट को लेके एक क्वेश्चन है which states, ours is a tenanted property since 1968, road touching. The original owner has sold the property to the builder developer who is constructing a plot behind ours next to our plot. Now the builder developer is well aware that our building has 12 tenants, 4 shops and 8 residential rooms at measuring 160 square feet. The building was declared unsafe to stay in 1999. Hence, we were asked to shift to safe accommodation by the municipal corporation in joint hands with the first land and structure owner. Till date, he has not given any rent to us for shifting, and now he has sold the plot and structure with all liabilities to the builder and developer. The builder developer is now saying that the 8 residential rooms tenants will be allotted 325 square feet room on ownership basis as per rule after paying 5,000 rupees per square foot plus registration charges for 8 residential flat. No parking shall be allotted. So for 4 shops, he says he shall allot only 325 square feet residential flat in exchange, as he has no provision for allotting small shops. He has already constructed big shop having area 1100 square feet. Presently, the building constructed by the builder developer violates National Life and Fire Safety Code. In near future, if all 4 shops and 8 residential tenants join him, there are chances of coming into trouble. Secondly, it is in Gautan area. We are low middle class people. As laymen, we request you to, with folded hands, please guide us and help us in the issue. Being low middle class income people, we can't afford legal help, and which the builder is well aware. Yes, sir.
Now, just listen to the complaint. It is not a very detail is given. First of all, the property, where it is say the Gautan, but Gautan is in a city or suburb. Generally, Gautan, and again he says the big commercial has been already constructed and a big building is constructed. So there is a mixed information. Just in a Gauthan, such a big building, if it is coming, I don't know how the plot is being bigger. So Gauthan always have a small property and other things. So there are the, and secondly, if the tenanted building, if the building is being demolished, it is very important before demolition of any building by corporation, they take the survey and they prepare a list of the people occupied. It is very important. Otherwise, the corporation will not demolish the building. Before declaring, after declaring danger building, if tenants are ready to vacate, then there is a statement, occupied list has been prepared with the area and a user. If that is available, then this can be a basis. Now we will study how the other development is there. So we require require to go in a more detail. We'll discuss with them and we'll give a better solution to them how to approach the other technical.
I think so. He should come forward with all the documents, and unless we don't see the documents, we will not be able to comment on that. So we need to go through all the documents and see the requirements, and then accordingly we can advise him.
It's very important that the tenant, before tenant is vacated, there must be some survey has been done by the corporation. And that is document, if it is there, is very important. Okay.
So now we'll continue with Samoon Rassiwala's presentation, and then there are many questions and answers are there, and then we'll take one after. Once he completes his presentation, we'll go further.
Now, in my earlier part, I've given the explanation regarding the technical part and other regulation. There are various regulations. Now, if this is very important, if the particular property is required to go under a double development, two regulations are applicable, 33A and then there is 33.7, 33.7B, 33.11, all these is to study in the particular case, and if a joint development is required, in joint development, the regulation is required, there are alternatives available. If it is only directly under coming the cluster development, what is the difference, then alternative workout has to be done. Or then two alternatives have to be given accordingly. If it is different, if public parking is possible, what is the benefit of public parking? All these will come in the calculation part. That is the third part. Now the third part are prepared without going in a detailed building planning, because these are the report which is prepared only for the feasibility report. It is not going for a complete planning of the building. From complete planning of building, we require a lot of other details and other you require a lot of time and other things. So feasibility report, we have to assume certain things. Assumption means what is the ratio between carpet area and built-up area. It is as per norms, carpet area built-up area ratio are taken 1.2. So then conversion. Then secondly, what is the ratio between the built-up area and construction area? The construction area depends on the type of the building. If it is going high rise means about 70 meter or 120 meter or going above 120 meter, then accordingly construction area ratio and the build-up area ratio change from 1.75 to, these are the assumptions. These are assumptions to arrive at a construction area. The construction area one comes, then construction cost comes. And the construction area will also give what is the payment to be done to the corporation. Then all the other department will require a built-up area, construction area and built-up area. And all the payments are being made to the department, building proposal department, fire department, and waterworks department. All are been based on the construction area and built-up area. So these are the assumptions that have been taken. And accordingly, all the construction cost and other costs, as I said, the rent also to be given, purpose fund will be given, all these will be included. If the land are to be purchased premium, if additional FSI is to be purchased, the premium, how much premium is to be paid for purchasing the additional FSI, then all also be considered. All these will be added up in the calculation. And that will be all shown in that calculation part. And that will be giving you total cost of the project. In the same time, after total cost, there will also be now there is all the sale. Sale has been done in the basis of the RERA carpet. Now there is a built-up area, then additional fungible area. All this area is a built-up area. the corporation plan approved basis of the built-up area. So then, while sale area as per the RERA, RERA carpet is required. So there is again ratio. We consider ratio a reduction from the built-up area to the RERA carpet to 20%. This includes fungible built-up area plus fungible. Then we come to the RERA carpet. Then some ratio have been decided, and that is considered. All these parameters are considered, and finally, what is the sale area? RERA sale area, carpet area available will be considered. Then this sale area available and total cost of the project, and accordingly, then we can work out what is the profit. If the sale area is available, market price is available, so we can work out the profit. So this project is, then we can work out if the developer is there. He says, I'm getting some percentage of how much percentage of profit. Then according developer will decide if the self-development is going on. They also will decide whether how much profit ultimately will give or will be survive everything. Secondly, if the self-development, if the people think that is all additional area which is available, if we purchase ourselves or increase our area by paying our own fee, all this can be decided based on this calculation. So all this come in finally, all these feasibility report has to be read with all available other data, and final decision are to be taken by society and developer. These are my complete detail about the feasibility report. Now, any question, we'll take it up.
Yeah, there are many questions. So we will start with the question and answer. That a building without occupation certificate and parking sold as flats can go for redevelopment.
See, without occupation is can be go for redevelopment. There is no, but then as I said, if you don't have an occupation, at least you should have any number of the approval when it is building been approved, and then otherwise you go for assessment detail when the first assessment is been done. If the first assessment is been done, the certificate is available from the assessment department. They will say the building was assessed, first assessment was done on this time, and then that is a start, that is a date which is been assessed. Secondly, very important, any changes, because what happened during the life of the building, if any changes have been done unauthorized and there is assessment increase, it is never considered unless it is been authorized by the corporation. And you're constructing mezzanine floor, you're constructing some loft and other thing, unless it has been regularized, this additional construction, or somebody construct additional open space area available, constructed open space, constructed one floor on the top, all this which is additional area which has been there, which is never considered. That's why the proof of the approved plan is very important. Showing that now, one case I will give you, I have gone through the one building plan and that was found that the corporation while finally approving, they said that this is some excess area, this additional one flat has to be demolished. So finally the builder has never demolished the floor, the flat. Today that particular flat is existing for so many years, but as per the approved plan, that building is, that particular flat is illegal. So that is very important aspect for this approval
Yes.
plan.
So any construction beyond the CC,
Beyond the approved plan.
beyond the approved plan will not be considered as an area for redevelopment, right? Suppose now if my approved area of my flat is 600 square feet, but I have encroached the balcony, I have encroached the flower bed, I have encroached the duct and everything, and now today I am enjoying 800 square feet, for example. So if my building goes for a redevelopment, I will not get the incentives based on the 800 square feet, because the 200 square feet which I have illegally unserved, right? So whatever the incentives I will get is on the approved plan, that is called the 600 square feet.
One more thing, as far as this flat is concerned, the terrace part, how much is going to be
The
calculated?
terrace is never taken in FSI. The terrace flat is not terrace plan. All the terrace are taken free of SI. So originally the corporation was approving the pocket terrace because of the very fashion design and other thing. They were today the corporation is not approving any pocket terrace except the last floor plus the ultimate floor that is permitted because of the adjustment of the area. So pocket terrace are always now counted in FSI. So pocket terrace, if it is counted in FSI, in approved plan, you get the
then you get the benefit.
Otherwise, all the covering terraces, covering otlas, extension of the ground floor, all these are not considered at all. That's why very important the society should have their all approved plan. It is very important to share, and a corporation is also will insist on that plan.
You mean to say that the terrace plan, it should be mentioned in the agreement.
Agreement, the agreement between developer and the purchaser is different. But approved plan should have the terrace. Let it be used as terrace or terrace. You will not get a reconstruction. You can plan a building and give him the terrace, but no construction area.
One is the common terrace and one is the terrace.
Common pocket terrace is never been permitted to be counted in FSI. So which area it is not counted, they don't get any benefit.
So in the nutshell, if you are having a terrace, but it is free of FSI, which is the premium has been not charged by the corporation, so you will not get any benefit of the terrace in the redevelopment. Now,
1 minute, I will make it clear. See, all these things which has been here by some of you are occupying, but you can negotiate with the developer in his profit in order to get his project done. If he is ready to give you, it is up to him. But legally, what I am speaking legally is something different, and negotiation is different.
Yeah, negotiation is, you try to say, sort out the matter amicably without going to the court. Now, there is one question. Please advise what is the meaning of fungible FSI? Is this free FSI for redevelopment that is minimum eligible for cooperative housing society?
Now the fungible, see originally what happened is Sulaiman ji just said, hey, you have increased the area of the tenement by covering your flower bed, your duct and everything. See, all this originally was permitted, but what happened? The builder was giving and selling this area to the purchaser. So purchaser was thinking, okay, these are my area, which is given by developer. So this is the area. So corporation has changed the rules in 2012 and bring the fungible aspect. So these now fungible aspect, whatever is permitted, all to be counted in FSI. Okay, these are all elevation feature. The flower bed and other things were taken as the elevation bed. There was a deck area, and there is a lily put and other many things which has been given a name. So all these are the elevation feature. There are some boxes to be prepared. All these boxes were recovered, covered and brought inside. All these elevation treatment now has been stopped. Now if you see new building coming, very simple, all simple chajja everything, because all the elevation feature are gone. They are now making elevation feature in the other material and the elevation, ready elevation they are coming up. But all these additional construction come as a part of the fungible. So government is done one thing, they who construct everything, all this area additional given. Now there are two parts. The area, fungible area which is given to existing tenant based on their existing legal area. Then only you get 35% free. But that fungible area will be only given to particular tenant. Then if you particular, if that is one, no distribution. If you are not giving a fungible to one tenant, then other tenants are given full tenant. All these there will be prepared. There is a one particular chart prepared called table number 21, where every tenant, as I shown you a table to you, that table will be having further extension. What is the area provided? What is the fungible permitted? What is the fungible given? And no excess area with any excess area given to anybody, which will be again counted in FSI. If it is there are some area with left, you cannot take over to the sale area. Then all area which has been available to one tenant, you cannot take over to other tenant, and no area of the rehab fungible can be given to the sale area. So these are very strict. Then secondly, the fungible available even for the sale area, which is charged, which is premium. Sale area which has been incentive area available on which self tenement are constructed. There are also fungible, but that fungible will be premium.
The premium will be paid. So, in the nutshell, this started in 2012 by the commissioner and Mr. Subodh Kumar.
So,
I remember very well because we had a discussion with him, and Mr. Ashok Chauhan was also the chief minister at that time. The discussion was that builders are using this what you call the tricks of having a flower bed and then having a niche area, then having a duct, and then everything was told to the builder by saying to the flat buyer by saying that तुमको 600 नहीं हम तो 800 square feet दे रहे. So 200 square feet they were charging to the home buyers, but EMC the corporation was not getting any premium of that 200 square feet. So Subodh Kumar came out with this novel idea, say that if it is going for a redevelopment, then 35% free fungible FSI will be given to the existing member, but that 35% will not be able to use on a sale component, right? You cannot transfer. That suppose यहाँ पे 3000 स्क्वायर फीट का rehab component है, उसमें 35 यानी 1000 स्क्वायर फीट मिलती है fungible area for the rehab component that cannot be transferred to the sale component and you can sell and make money. So even 35% is given on the what you call on the sale component area, but the builder has to pay the premium. So nothing is free now. No lunch is free. Now one more question which has come is, apart from 35% fungible FSI, any other FSI incentives are given to the existing member apart from 35%?
that is which scheme we are going. Now this I will talk to you. If you are going for the 33-7, it is the sales building, and then you have the cluster development. The cluster development, they are getting additional FSI because the government wants like a small development, small plot development, the provision of the firefighting equipment and all other things. It is very difficult and it will not be possible. So then open space of 6 meter and other things. So they are encouraging all the small plot to come together, and I will just refer to our Bindi Bazaar. Bindi Bazaar, there are small 200, 300 square meter plots. All these cannot be developed independently. So all these small plots, about 250 plots, have come together to come with a big scheme. So you can come all the small plot and together, then all these additional FSI, additional entitlement. This is called additional entitlement. In 33-7, they are giving additional, even 33-7A, that is the old tenant building, also been given entitlement. 2 buildings, 3 buildings, accordingly, that is all been given. And a particular regulation you have to see, and accordingly you get additional.
So, if you want to have more incentives or entitlement of FSI, one is the width of the road, and second is if you go for a cluster development, nothing like it, you will get very well planned like a township. What you see in Pune, in Magarpatta, and all, if you come together, and what we are seeing in Bindi Bazaar, once it is ready, you will understand that how the cluster redevelopment has changed the life of the people staying there and uplift their standard of living. Now we come to one more question. There are many questions on the YouTube. That is occupancy we have answered. Advise the fungible FSI. Sir, in last 60 years, there is a case where the property of the managing committee has been attached and auctioned in Mumbai or Maharashtra since most of the MCs do not do due diligence and appoint worthless builder. So I don't have any question for this. We'll have to do a lot of research and find out that how any MC members have been penalized for suggesting wrong EMCs. So that's why we, as a Citizen Justice Forum, we want to empower you so that you understand what are your fundamental rights. If the society is going for a redevelopment, first thing is don't go by the figures, the Excel sheet which is circulated by the managing committee that this is your existing area, you are getting this additional area, you are getting so much rent and you are getting so much corpus fund. So that's why I every time insist that you first do the feasibility report from an independent architect, find out the history, geography of your plot, understand what is the potential of your plot, then you can negotiate with the builder because you have more understanding of what is the potential of your plot, and then he will suggest you that which is the scheme where you can get the optimum benefit and Now, suppose if it goes for a very, density, so instead of 60 flats, you are getting 180 flats, then again it will create a lot of problem. So that it has to be balanced, and you should have a very well experienced architect who is very well versed with this, all this. There is one question from Chapraji also about the redevelopment.
First of all, I will seek an excuse in advance because I have very shallow knowledge about the redevelopment. Even I don't, if I honestly say, I don't know the elementary knowledge. But a practically client of me is now currently relative. He has specifically personal to me instead of your good son. He says that there were totally 60 members in the society that is going to be redevelopment. A particular builder A was appointed. Later on, A was terminated by an agreement, mutual agreement. Now the society wants to reappoint another builder. In SGMs, 79% voting in favor of the new builders. Only 2 members are contesting members. They are opposing the appointment of that particular building. So if those they 2 people are opposing, it means they are not in non-cooperation. Their 2 members has already approached the Honorable High Court, Bombay High Court. Even the first builder A has filed compensation case against the new builder as well as the society for his monetary loss. So my simple question is, if my client is not interested to hand over his property to the society, whether the redevelopment can be continued during the pendency of the litigation before the Honorable High Court.
This is purely a legal issue.
Legal issue.
So I will answer this issue. See, the development can continue if the erstwhile developer who is being terminated, if he obtains any stay order against the new builder or the new construction, then the work can be stopped. If he is not able to obtain that, that means the work can continue. And if you are a minority, there are many judgments by Honorable High Court and Justice Gautam Patel also, that minority cannot hijack the redevelopment project until and unless there is you find a flaw, right? To find something which is going to harm your fundamental rights, and if you are able to convince the court, then definitely your concern will be addressed, right? Even the High Court recently, one of my blog is also done, and I made a small video that High Court was the opinion that at the age of 70, the senior citizen should not suffer because the delay of the redevelopment of the project. And court is taking, every week there is a hearing going on. So I'm keeping an eye on it. Once the final order comes, I'm going to make one more video on that, so that even court knows that at the age of 70, if the building goes for a redevelopment, instead of 3 years, it's going to 10 years. If that, I don't know whether if at the age of 70, I'm going to leave for the age of 80 and see the new flat or the new home, or I will see the new world. So even the court is conscious about it. So something good will come out of this. So I think we should. One more question has come. He says he will give us only 250 and rest we have to pay. She is a widow and she does not have that money. So what I suggest is, see, before going into these figures, these questions cannot be answered to you without looking at in depth the documents and the correspondence, what has happened with the society and the builder. So we need to have some documents to suggest you some remedy. So I hope everybody enjoyed this session, and we are at the concluding part. So stay tuned to our channel for more updates on legal matters that affect you. If you find this video informative, then like, subscribe, and share with your contacts and friends for more engaging content on legal issues. See you again in the next video with a new topic. Till then, take care, stay blessed, be safe, and remain healthy. Satyame Vajayate.